Good evening. Welcome to Lawyers on the Line. I'm Bob Falsani, founding partner of the Falsani Balmer, Peterson, Quinn, and Beyer firm, and this evening's moderator. The main topic for tonight is workers' compensation. When an employee gets injured on the job, that employee has a right to a number of benefits under the law. Handling medical bills and wage loss, changing doctors, getting back to work, and just navigating the system can be very complicated. I'm pleased to welcome tonight's panel. Eric Beyer of the Falsani Balmer firm, Sean Quinn of the Falsani Balmer firm, and Don Erickson of the firm of Fryberger, Buchanan, Smith, and Frederick. And Don Erickson is a former workers' compensation judge and a defense lawyer and a lawyer that represented injured people. So we've got a kind of a special guy on tonight with us, so I'm looking forward to it. Just let's start out a little bit since we have the former judge here. Why do people get so unhappy sometimes when they lose their case? What do you think is the most important thing, other than money?
Other than the facts for the case itself?
Yeah. No, I mean, they lost the money, but why are they outrageously unhappy sometimes?
Well, they've lost the case, they've lost their job, and they don't have any compensation to make up for it except possibly unemployment. It puts them in a bad place. Many times they can't go back to that type of work. So in the future, they're looking at a continuing wage loss, possibly for the rest of their life. I mean, it's very important for an injured worker to have a good attorney who knows the work comp system. There's not all that many that do. It takes a specialized attorney, in my view, and it's very important for the employee to get a good attorney, I think.
Now, Mr. Quinn, do you have any thoughts on things that Judge Erickson did as a judge, even if he decided a case against an injured employee, to make them feel better about it?
Wow. These were not the pre-planned questions. Wow. Don was a fantastic workers' comp judge, quite honestly. He treated everyone who walked into his courtroom with a lot of fairness and dignity. He gave everyone an opportunity to be heard, whether it was a witness for the employee, a witness for the employer. He gave the attorneys the full opportunity to argue their cases. I enjoyed trying cases in front of him, quite frankly. I kind of wish he still was a work comp judge at times.
Right. Let's go back to something simpler then, okay? Eric, would you like to tell us just the basic benefits under workers' comp,
Sure.
what we can look at?
Sure. In Minnesota, first of all, the most important benefit is medical benefits. You're entitled to get reasonable medical care for as long as the injury persists and as long as you can prove it's related to the injury, to the work comp injury. Temporary total disability is wage loss paid at 2/3 of the average weekly wage, and there are some caps and limits on that. Temporary partial is wage differential if you go back to work and you're not earning as much because maybe you're on restrictions or you can't do the job you used to do. Permanent partial disability is it's compensation for loss of function. Sometimes in layman's terms you might say it's kind of like pain and suffering because it's not related to any wage loss per se, but it's woefully inadequate to compensate people for it. But that's based upon a percentage of loss of function to your whole person. And rehabilitation is a benefit that allows people to, or helps people try to get back to work. It helps them try to get back to their date of injury earning capacity, and there are many ways to do that. Job search, help with job search, on-the-job training, retraining, which can go as far as going back to college, perhaps. And then there's permanent total disability, which compensates a person at their workers' compensation wage rate is if you can prove that the person is unable to obtain anything other than sporadic or insubstantial employment, and that's payable up until age 67 in Minnesota.
I guess we're done now. You've covered all these benefits.
Covered everything.
We're going home then.
That's the show.
Yeah. Just a few points. Let's talk about a few controversial things in these categories. First of all, in medical, there seems to have been a tremendous amount of increased spinal surgery in our society, especially we see it in workers' comp cases, but we see it across the board. Is anything being done to address that in the workers' comp system?
Well, there's always been, or at least for a very, very long time, the right of the insurer to have a second opinion doctor. They call them independent medical examiners. We call them adverse medical examiners. But these are doctors hired to give another opinion as to whether or not somebody needs whatever the medical care is, including the surgery. There have been some efforts recently by the Department of Labor and Industry to really put a cap on fusion surgery and really limit those types of surgeries, when they can happen, and a whole bunch of hoops to jump through before one can even be approved.
So let's say it's a fairly controversial fusion surgery at 3 levels, okay? And so what's the likelihood, in your view, Don, of somebody coming out ahead on that?
I have seen where the surgery has helped some people. I've seen many cases where it hasn't helped people. In some of these cases, we used to see what were called anterior-posterior fusions, in which you needed 2 surgeons, one a thoracic surgeon to go in from the front, and the other a neurosurgeon to go in from the back, and together they would put apparatus to stabilize the spine, metal with screws to immobilize the spine and to stop the pain. We're not seeing that much of that anymore. I think the results from that surgery remains to be seen how long it will last. I've seen where it's helped some people get over their pain and become productive again. So it's a controversial subject. It works for some, it doesn't work for others. And sometimes it's the only thing that can be done.
I think it's pretty clear also that despite you talked about fusion surgeries in the low back are really controversial. They're not as controversial for a single level in the neck, and what is really not in controversy much at all is persistent radicular pain, or when a person has pain going into their legs. That usually can be fixed pretty easily without such a dramatic type of controversial
All right, well,
surgery.
another medical question is, let's say you're really badly injured and you end up in the nursing home. Is that covered too?
Oh, sure. That's the medical expense includes, surgeries, doctor visits, nursing home, therapy, medicines, even medical mileage is covered.
Frankly, because there's so much covered, and because the cost of medical care is obviously, we all know what's happening with that. It can be pretty contentious at times with the work comp carrier.
There's a question here. Why is it so hard to find somebody to represent an injured party in a federal workers' comp case?
Oh, there's a lot of reasons why it's hard, but the number one reason hard to find a lawyer is because the federal workers' compensation system is designed to make lawyers not want to take them, because they really limit attorney fees. I mean, substantially limit attorney fees, where an attorney, if he's successful in the claim, might end up breaking even and might actually lose money in the end.
That's part of it. I think that the other thing is workers' compensation is so specialized. As Don mentioned, there aren't very many people who do it. Federal workers' compensation only covers postal workers or other federal employees, maybe
Border Patrol, maybe up here.
Forest Service. So it's just such a small area to try to become up and expert on that it becomes difficult to really, I think, to handle it.
I had some experience with that, and what I've found is that the system is so cumbersome. I mean, you write a letter to the adjuster, the federal adjuster, and you get an answer in 9 months, and by then your client is about ready to wring your neck. And I mean, you don't run the federal government either. So
Right.
anyway, another question. People are trying to defraud comp claims. As an employer, can I protect my company? Somebody's got some strong attitudes here.
Well, I'll let Don answer that. That's
Well, I've both defended employers and I've helped employees obtain benefits. It's important for an employer to, first of all, have a policy that requires the employees to report injuries. and to report them as soon as they happen, whether they're major or minor. If the employer is insistent on that, they won't get injuries. They won't get injuries that are made up. They'll be able to advise their insurer of them and have them investigated properly. Going back to the question, though, as a judge, of all the cases that came before me, there were very, very few, a very small percentage, lower than 5%, perhaps lower than 3 or 2%, that I considered to be fraudulent. I think it's something the insurance companies have used in their literature to try to convince both jurors in the civil arena and employers that employees don't deserve money when they get hurt.
Do you find sometimes employers think something is fraud because they don't understand the law or the legal rules involved?
Well, I think there's a whole host of reasons why they might think it's fraud. I think that the primary reason somebody might think it's fraud is it might be costing them some money and they don't see it, they don't experience it. When somebody can show up for work and do some things, or maybe actually go fishing on the weekend, it doesn't mean they're not hurt. It doesn't mean that they can't do all the things that they would hope to do. It doesn't mean they don't need medical care. And I think that's just kind of a cognitive dissonance thing from the employer's perspective.
So here's a question that might result in employers saying it's fraudulent, and we know it isn't, but somebody has 2 herniated discs in 2010 and doesn't say if it's a work injury or not, and then re-injures their spine at work, and then wants to know if they can make a claim for re-injuring their spine.
Yeah, and the answer, of course, is yes, you can. As long as the work injury is a substantial factor in the need for medical care, the time off work, whatever it may be, then there is a workers' comp claim. There can be other factors, including pre-existing conditions, congenital conditions, other injuries that happened at other employers, and then you might have a multiple employer workers' comp claim. But as long as the work injury is one of the factors, as one of the substantial factors, then there's a claimed injury, an injury that the claim will be paid. And the employer also takes the employee by law as the employee comes, because none of us are perfect physically, and we all have our infirmities, and that's just the way it is.
You know, interesting. I think that goes right to the point where maybe employers may say that something isn't a legitimate injury because doing something might not necessarily cause a person without any prior potential to be injured any problems. A 20-year-old might lift something and do fine. Somebody that maybe had some prior back problems might get seriously hurt, and the employer says, well, it's because of the old injury. Well, the system is designed to make sure that we cover anybody who's working and gets injured, and that risk is spread. It's spread very broadly societally to cover those kind of injuries, and that's, you know.
Let me follow up on this. Don, do you advise employers sometimes as far as whether they should have physicals done on their employees, new employees when they hire them, to try and see what their baselines are?
Well, I do employment law as well as work comp, and under both state and federal law, an employer has the right to have the employee physically examined to the extent the physical examination relates to the job duties. So I do advise the employers to send the job description to the doctor, to have a list of the physical duties and requirements, and to only test for those requirements. Not to take a family history, because that would violate the what's called GINA, the Genetic Information Law. Not to give me a synopsis or give the employer a synopsis of every condition they have, but solely to examine the employee for the things that relate to the job they're being hired for. If employers fail to do that, the employer could have either a state or a federal disability discrimination claim. So yes, I do work with employers. We tailor the examinations, and I do advise them to limit it to the essential duties, but you need to make sure. If the job requires lifting 50 pounds, the examination can require them to lift 50 pounds. So it has to be very tailored.
We have a question addressed to Eric and Sean, and that is, for one of you to take, when should people hire an attorney in a workers' comp context? And, they obviously don't always need an attorney if they get hurt on the job. When should they think about hiring somebody?
Well, I know Eric and I sometimes even disagree on this, so I'll give my answer and he can follow up. I think there's nothing wrong with at least calling and talking with one. You don't even have to necessarily hire one, just to get an idea of what to expect and what to anticipate. But one of the telling events that often takes place in a workers' comp claim is what I spoke of earlier, when the insurer says, hey, we're going to send you to a doctor of our choosing. That's a real good time to hire a lawyer, because something's going to happen. That doctor's going to find that you're not as hurt as badly as your own treating doctor, most likely. So that's a good thing. Sometimes they want to cut off your benefits. Sometimes they want to put you in a different job duty within the employer. So those are the types of times when it's at least a good idea to talk to a lawyer, and you can choose to hire the lawyer or not at that time. It also relates to attorney fees. If they're paying benefits, you can hire an attorney. The attorney cannot charge fees against the benefits that are being paid you voluntarily by the insurer, only if the attorney helps you get benefits that weren't otherwise being paid.
When should you contact a lawyer? Pretty much the day you get hurt or right away? Is there a circumstance where that's a good idea?
Well, I think that it never hurts to call a lawyer whenever you have a concern or question. I mean, this is a very complicated system. And we only take cases that, we only get paid on cases where there's a dispute. And sometimes, many times, somebody will call and just has a lot of concern, a lot of questions. They don't know what to expect, and then they can get advice. And then on a case-by-case basis, maybe they need to hire the person, maybe they don't. So I generally, you'll sleep better at night if you call somebody and you get some answers. I mean, that's generally the way it is. When I would say maybe in a third-party case, you want to call somebody if you're delivering a package and you get hit by a car by somebody else while you're on the job. Well, now you've got a work comp claim and a third-party claim. So there is going to be a different type of litigation, and that's important to probably contact a lawyer right away. So.
Okay, Don, if you have a situation like this where you're hurt on the job, but you have legal rights against a third party, a product manufacturer or a driver of a vehicle, or maybe a premises where you had to go to make a delivery was dangerous and they didn't tell you about it. In that circumstance, do you get paid double? Do you get all the damages on the civil case and then get all the damages in the workers' comp case, and they don't know about each other? And
No, our system prevents double pay both for attorneys and for employees. If a person is hit by a car, for example, and they bring the work comp claim, the insurer will have the right to recover. There's formulas in the law that tell how much the insurer gets back of their money after they pay a work comp claim if the employee then sues the driver that hit them. I generally tell employees who have both a third-party claim and a work comp claim that in the work comp claim, they're going to initially only get 2/9 of the damages awarded. That's how the formula works out. After that, the work comp insurer is going to be reimbursed 2/3 of the money they paid, and only after the work comp insurer is reimbursed will they then again get money or possibly lose some of their work comp benefits. It's a complex system, and you need an attorney in that case that knows both third-party personal injury law as well as work comp law. And then the third-party case might be an underlying case. It could be anything from medical malpractice to a products case to a negligence case. So you need a lawyer that actually has a couple of specialties or is willing to work with an attorney who understands those things.
all right, and then so if somebody gets hurt and there's a chance for suing somebody else, that person should call a lawyer that knows this kind of work right away, right?
That's absolutely true.
All right, just so everybody knows that one.
Right.
Right. That's a
That's
good one.
black letter, isn't it? I mean,
Pretty clear.
it's a
Yeah.
smart thing because
Yeah.
you can't take pictures when the situation's gone later and it's changed or whatever, the defect that somebody gets hurt on or whatever. Right?
Pictures, witnesses, all
Everything.
kinds of things.
All right. This is another call in we got. My husband got hurt at work, and other workers are working mandatory overtime, and the employer will not pay for the overtime, even though it is out. He is out injured. Is that right? Even though he's out, not pay for the overtime, even though he's out injured. So I think what they're saying is everybody else is getting overtime, and he's out on workers' comp, and he normally would be getting overtime, but he's not getting anything extra.
Right. If he's completely off work, he only collects the temporary total benefits that he's getting, and those are going to be based upon his wage at the time of the injury, not the wage that he might be getting if he wasn't hurt.
Right.
If they're talking about something else, like he's working full-time but he's not getting any overtime hours because he's injured, then that might be potentially some sort of discrimination claim, but it depends on what his restrictions are too. So,
Yeah.
Here's another hire a lawyer case or question. Having shoulder surgery soon, don't have a lawyer yet, don't know how it's going to turn out. Should I hire a lawyer in anticipation of what might occur? Difficulties getting the job back, getting permanent partial, so forth and so on, retraining, whatever it might be. Would that be important to hire a lawyer just when you're going to have surgery, or is that one of these things, talk to a lawyer?
Well, hiring a lawyer, I think by a lot of people means that the point in which you sign a retainer agreement and then that person represents you. But in this kind of law, you don't need to do that. The attorney may not need to do anything, so it always makes sense to call a lawyer. And you just call a lawyer and you find out whether or not there's any circumstances specific to that person's case where they might need further representation. There's going to be a lot of unknowns for that person. They're going to have a lot of questions. They can usually get those answered, and then they can call that lawyer again should any problems arise. So.
What's the chances of getting retraining if you don't have a lawyer, Don?
It's absolutely zero. And retraining in work comp is a very valuable benefit. You can obtain not only your wage loss for 156 weeks, but you can obtain your full tuition, room, board, books, transportation. It's the only place where you can get paid going to school. Insurers don't ever voluntarily give retraining. Every case I've ever seen in which retraining has been granted, the employee has had to go through a hearing. It may be that in most cases the insurer will want to settle out the case, give you the money for the retraining, but have no further exposure. But in all cases, it's going to involve a fight.
Yeah, and I think Eric touched on it, the key word being hire a lawyer. Sometimes, and I know Eric has this experience, Don probably does too, I will get hired, but I'm not doing anything because there's nothing to do, but at least I'm there to answer questions for the employee.
Well, here's one that I always like to answer because it makes me so angry.
Great.
Husband works for the reservation, off 7 months on workers' comp. Saw an orthopedist one time, that was an adverse, of course, insurance company doctor thing. Said he can go back to work. Anything he can do. What's the answer?
Nope. The tribes have their own workers' comp system, different from Wisconsin or Minnesota. They're governed by their own laws, and they have their own rules, and they really substantially limit benefits even more under most of those policies. Each tribe has a different policy, so it depends, but there's not much.
I call it third world workers' comp.
Well, it's an independent system within there. You would have to literally go to a council meeting and...
Well, they have, one of the ways is you have appeal, but your appeal is before, the first appeal usually is before the insurance adjuster. You got a real good chance there. And then, it's very cumbersome and limited benefits, so we won't handle these usually in our firm. How about you, Don? Do you-
No.
No.
In fact, I turned one down today.
Yeah, it's the same as federal workers' comp. Nobody wants to touch it with a 10-foot
Well, it's even worse.
pole.
It's a different
worse. It
structure.
is worse,
It's
yeah.
a different structure. So
Have workers' comp from a while back, and my injury is acting up again. Will I have any rights now?
As long as you haven't given them up through a settlement, yes. And you might have a claim for the old injury. There might be an aggravation of a new injury. It might be both.
Okay. I think we're getting to the end of the show here, and so that's all we have for tonight. And you can watch the show again online if it was scintillating, and you can go to our website at Falsani Balmer, Peterson, Quinn, and Beyer and watch it again. After you've watched it 3 times, I'm sure you're going to be very happy. So, but there is some information here that we think is valuable, and we hope you thought it was valuable as well. If you have any questions beyond this, you can call the Volunteer Attorneys Program. They have an Ask an Attorney service, and you could call the law firms of any of the participants tonight if you had questions, and we all are competent about this. Now, next week we're going to be talking about auto collisions. And I'd like to thank our panelists for tonight for their expertise. Nice job they did. I'm Bob Falsani, and good night.